Well, hello there and welcome to another edition of the Employment Law Show. Good to have you along for the half hour. John Scholes, your host, and with me, Lior Samfiru from employmentlawyer.ca. You're always encouraged right off the top, as we tell you every week, to reach out to Lior and his team if you have any questions beyond this half hour, something comes up in your mind you want to ask. You're invited to do so, 1-855-821-5900, help@employmentlawyer.ca. And the website that was designed, built just for you. It's free, it's anonymous, you'll learn a lot from it and have access to that severance calculator. It's baked right in there. That would be pocketemploymentlawyer.ca. We'll refer to that in just a few moments. Main topic in just a bit, what you should know about employment contracts. That's coming up later on the show. Some phone calls from our radio shows. It is jam-packed every week, Lior, so we'll get to it. The week that was, what's going on your end, pal?
Hey, John, great to be here. Great to be talking about employment law and hopefully solving as many issues, as many workplace problems as possible. We talk about this topic because we all have jobs. So we all have a right to know what our rights are. It's a right that we have. Though if we have employment laws but no one knows what they are, well, they're kind of meaningless. By watching this show, you will know what your rights are if you're facing a workplace problem, if you lost your job, if your boss is not behaving him or herself, if your job is at risk or in jeopardy or it's changed. You got it. I think this is the time, this is the show where you'll arm yourself with that very, very important knowledge. And of course, beyond the show, because we're here for 30 minutes, but beyond the show, there's no limit to when you can contact me and my team. We'll give you that phone number and that email address throughout the show. So don't be bashful, reach out so we can have a more in-depth discussion about your rights. But I always like to start off with the situation that came across my desk. Now, John, we've said many times on the show that when it comes to severance, it has to include all components of your compensation. Yep. Well, I have a really good example as to how, in this particular situation, an individual had some significant components that were not included as part of their severance. Well, I spoke with a gentleman that was a superintendent in a building. And he'd done that job for a number of years, and as part of his compensation, of course, he used to live at very minimal rent as in the building. So he paid almost no rent, and that was part of his compensation that he got that apartment. Well, recently building management changed, and they decided to make a change in superintendent and let him go. So they told him that we're going to pay you some severance, but we need you to vacate the apartment within 2 weeks, as we're going to bring someone else in. So he had been there for a total of 6 years, and he wanted to know what his rights were when he called me. So first of all, I assessed him as being owed about 8 months severance. He was an older gentleman, been a superintendent for 6 years, 8 months severance. But part of his compensation, of course, was that apartment. What does that mean? That means that his employer, the management company, would have had to either allow him to continue to live in that apartment for 8 months, or to pay him an additional amount of money that he can use then to rent another apartment somewhere else. In other words, that apartment, being a part of his compensation, had to be accounted for as part of his severance. They didn't do that. They said, we're going to give you 3 months severance, which is inadequate, but beyond that, you have to vacate the apartment immediately. No, that's a wrongful dismissal. So I'm working with him now. I'm going to get him the value of that apartment so that he can rent one for 8 months. But there's an important reminder there for all our viewers. When it comes to your severance, yeah, your employer's not going to forget about your salary. But what about your bonus, your commission, your benefits, your apartment, your car allowance, your pension? All those components of compensation have to be accounted for. If they're not, you are owed more. So it's not just for how long you're going to get paid, the number of months. That's one issue. It's what's included in that. If you lose your job, let's have that chat to make sure that you get everything you're owed.
It sounds like in this case he's going to have to move out regardless because someone else needs the spot, but maybe he can move somewhere else in the building, but financially he should be okay and taken care of for that length of time, right?
Yeah, so let's say that apartment to rent would have cost $2,000 a month as an example. Well, they have to add another $2,000 a month for 8 months that he can then use to rent an apartment either in that building or somewhere else. They can't just say you're gone and we're not going to compensate you for the loss of the apartment. That's a significant part of his compensation.
Would that be something they could or should put in an employment contract, or it's automatic because he has to live somewhere?
No, if they could have eliminated or reduced that obligation in an employment agreement, because they did not do that, they had to account for it as part of his severance.
Same thing goes for salespeople and everything when it comes to company cars, cell phone, commissions, all that stuff. You have to be made whole, right? I think is the expression you've often used.
Well, you ask yourself a very simple question, because some people ask me, well, is this included or is that included? You just ask yourself this question: would I have received it had I continued working for the severance period? If the answer is yes, then it has to be included as part of your severance package as well. So it's not just your salary, it's everything you could have expected. Gym membership, for example. I know, you understand the importance of that for many people. Well, that could be expensive. If you have a gym membership as an employee, that has to be accounted for. So all components of compensation must be accounted for.
Employmentlawyer.ca, great website for you to use anytime. While you're there, you can find out where we host our radio shows pretty much across the country at this point, have been doing those for years and years. And we always invite you to tune in the radio station, not only listen, but grab a phone, call us during these hour-long or half-hour-long shows, depending on where you catch it, right here in the GTA as well. You'll catch us on AM 640 and various other stations. But we get a lot of phone calls. People want to know things that aren't explained every time on air. So we talk to them. And sometimes we take the great phone calls, we chop them up, we play them back here, and we dissect them a little further. Lior, let's get to our first phone call for the day right now.
Laid off this week due to corporate restructuring. The catch is that I have a baby on the way, and I was only offered 1 week severance. I tried to send an email to them to negotiate it a bit higher given the circumstances, and they said that they're going to only offer what the minimum available is. And that it was a marketing manager position making around $100,000, and I'm around 30.
What do you think?
So the first thing that immediately jumps to mind is she's being let go because she has a baby on the way. Or at least the timing is such. Now, if she was let go because of that, if the fact that she's having a baby formed any part of the company's decision to let her go, it's illegal. The company can't even have that be 1% of the reason as to why they're letting someone go. That would be a human rights violation, an employment standards violation. It's a big deal and it's illegal. That's first thing. But even if we put that aside, let's assume the reason has nothing at all to do with the fact that she's having a child soon. That nonsense of, well, you get a week per year of service, it's just that. It's nonsense. It's not the law. You are owed significantly more. Now, your minimum entitlements may be 1 week's severance or a week per year of service, but your full entitlements can be 10 times that. So this is a wrongful dismissal because this person, even if we forget about the upcoming baby that she's expecting, is owed much more severance. So the question, of course, becomes how much severance is she owed? Very easy to find out for her and for you at home. We're going to use our severance calculator, show you just how easy that is. We're going to go to pocketemploymentlawyer.ca, use the severance calculator tool, and let's see what that gives us. So we know that this person has been a marketing manager for 1 year. She's 30 years old. Company says, yeah, you only get a week severance. Nonsense. You see right there, she's owed right around 3 to 4 months of severance. 3 to 4 months, that's a big difference. That's somewhere between 13 and 17 weeks, not 1 week. That's why it's so important to use that severance calculator. Of course, it's free and anonymous. Check it out for yourself.
Phone call number 2 from a radio show, guys, coming up right now. Let's get to it.
Construction health and safety coordinator, and I was working with a company for about 4 months past the period of probation. Had actually someone who brought me into the firm, actually, and I was just terminated with no reason at all. That was it. I went in for a meeting, and they said, bye-bye. I did your severance calculator. It says I'm entitled to 3 to 4 months, but that can't be right?
Oh, yes, it can.
Well, I'm smiling here because I get that often with short service employees. People say, well, I've been with the company for 6 months, 8 months. How can I be owed several months of severance? Well, guess what? That's what the law provides. With respect to short service employees, those individuals are treated disproportionately better when it comes to severance than longer service employees. So yeah, it's absolutely possible and likely that even after a few months of employment, if you lose your job, you are owed a few months of severance. It's not wrong. It's not a bug in the system if you use the severance calculator. It's simply the law. So in the first 3 or so years of employment, you're going to get severance. It's going to be disproportionately higher than if you were a longer service employee. So remember, just because you work somewhere for a short period of time doesn't mean you get little severance. The opposite is true.
As always, we do 3 phone calls per show, but the third phone call is on the other side of the break, which we'll take now. And we're going to get to our main topic for the show as well. What you need to know about employment contracts, that's on the way, so stick around. In the meantime, 1-855-821-5900, help@employmentlawyer.ca through email, and we'll continue with more of the Employment Law Show. Stay right there. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Employment Law Show. So good to have you with us. John Scholes, Lior Samfiru, reaching out anytime, employmentlawyer.ca or pocketemploymentlawyer.ca, the website. And phone calls always welcome, 1-855-821-5900. Main topics coming up here in a minute, but I mentioned the third phone call from our radio show, Lior. Let's roll that and get into it.
Well, I've been on a long-term disability for quite some time now, and it looks like through via tests that I could be stabilizing and may look at going back to work. However, I'm 64 and next year 65, and wondered if they still have to take me back to work in a reasonable or same position. I have 7 years with the company, and if they don't, is it constructive dismissal?
Excellent question. Very, very good question, an important one. And the answer here is very straightforward. Absolutely. First of all, we don't have mandatory retirement. What does that mean? That means that you can go back to work and continue working as long as you want. There's no cutoff at 65 or any other age. So you're treated at 64, 65 the same way from a legal standpoint as you were treated if you were 25 or 35. So if he's on a disability leave and he's ready to come back to work, his employer has to make all efforts to bring him back to work to the same job and the same pay. If he needs accommodation, and he has a doctor's note outlining what that accommodation is, the employer has to make it happen. Maybe it's modified hours, modified duties, etc. Company has to do it even if it's difficult. They still have to do it. Now, if the company has tried and nothing is available, there's just nothing there, he's been off for too long, the job doesn't exist anymore, then and only then can the company terminate his employment with full severance. And by the way, if he's older, 64, and maybe not yet in optimal health, that means even more severance than he would get usually, because it's going to be more difficult to find another job. So yes, you have significant rights if you're coming back from a disability leave, whether you're younger or older. Company has to try to take you back, make all efforts, and accommodate you, of course, if you have that need.
Is there a threshold to that, how far you have to go as an employer or a company?
So when it comes to accommodation, it's what we call accommodation to the point of undue hardship. So that means that even if it's difficult, even if it's challenging, your employer still has to accommodate you. Now, at some point, it's going to be so difficult that it's going to be so costly that the company may not have to go that far. Unfortunately, what I've seen time and time again is situations where employers don't reach that milestone, that threshold. They say it's too hard before it really is too hard, and that's a human rights violation.
We'll move on to our main topic. This is a good one, the employment contract, one of the most important pieces of paper you will sign for your entire life. Think about it, it's your work life if you stay at the same employer for years and years, right? So let's get into what you need to know about. Number one is this, Lior. It is an employee's best interest not to have an employment agreement. You're thinking, what? No paper? No nothing? What? I feel naked.
Absolutely. I'm going to repeat what you just said. From an employee standpoint, it is in your best interest not to have a written employment agreement. You would much rather have a job start on a handshake deal or find a nice napkin, jot a couple of lines, sign that. That is much better than having that 10-page employment agreement. And let me explain why. The way our employment laws work, frankly, across Canada, is that the laws are there automatically to protect you. They're there whether you realize it or not. But the laws also say, well, if you don't want us, we'll go away. If you want us to be eliminated, you can eliminate us. We're not going to make you have rights. Well, that's what an employment agreement does. It takes away the rights you would otherwise have automatically. So I can promise you that in a 5, 8, 10-page employment agreement that your employer wants you to sign, there's going to be a bunch of stuff there that has the effect of taking away rights that you would automatically have. Whereas if you don't have an employment agreement, you have a handshake deal, you have all the rights. All the rights are still there, they're available, you have not given them away. So don't be concerned to start a job on a handshake deal. Be concerned to have to sign a 10-page document with a lot of legalese. I can promise you that that document is not going to be good for you as an employee.
Don't ask for it.
Oh gosh, do not ask for it. And I've seen that happen.
I want a contract now.
You better give me something to sign, and the more words, the better. No, you don't want that. Be happy if you did not sign an employment agreement. Maybe your employer forgot to have you sign it. Be grateful. That's a good thing for an employee.
Okay, before we move on, that's an interesting fact. So you start day one, and then they come up to you at the end of the day, say, you want to sign this for us?
So very, very good. And one of the things I look at when I look at an employment agreement is when it was signed. And the reason for that is for an employment agreement to be enforceable, you would have had to sign it before you started working. If you signed it after, in many cases, it's no longer enforceable unless you got something in return for signing. So very important. Now, I'm not suggesting you sign something saying it's not going to be enforceable later on, but it is still a good idea to look at the date the agreement was signed.
Point number 2 is this. Clauses in an employment contract can limit an employee's rights and entitlements, which you were talking about moments ago.
So let me give you examples here of how it can limit your entitlements. For example, we've talked about on the show thousands of times how you have a right to get your full severance. That could be as much as 24 months. Well, an employment agreement can limit that severance to a fraction of what it would otherwise be. And that could be the difference between getting 24 months, i.e. 2 years of severance, and getting 8 weeks of severance. So if you sign an agreement that limits your termination entitlements, that could cost you at some point tens of thousands of dollars, maybe hundreds of thousands of dollars. A big, big deal, huge deal. Probably can't think of anything bigger, but it doesn't end there. An employment agreement can get around things like constructive dismissal. An employer can't just change your job, your pay, your hours of work, unless you sign an employment agreement that says that. And oftentimes, that's what the agreement is going to say. Yeah, we're going to pay you $65,000, but we have a right to change your pay, or to demote you, or to reduce your hours, or to relocate you. Things a company can't otherwise do. An employment agreement can also give the company the right to put you on a temporary layoff. Company can't do that, right? And there's no legal right for an employer to put you on a temporary layoff unless you sign an employment agreement that gives them that power. These are just a few things. There's many more ways where an employment agreement can take rights that you would otherwise have automatically and eliminate those, make it so they don't exist. So I'm not trying to scare anyone here, but you have to be mindful of that. And the one thing I want to say is this. I'm not just telling you these things to scare you. I'm telling you this because you can actually negotiate these terms. If you identify them, if you understand what it does, you can go back to your employer and say, hey, employer, I'm uncomfortable with this, can we change that? And in many instances, that's actually going to be something that your employer does. If you're not sure what the agreement says, if you just got that offer and you want to understand what it does and says, send it to me and let's have a chat.
Everything you need to know about that employment contract, that is the main focus of this show today. Number 3, Lior, is this. Employees, mind you, cannot be forced to sign a new agreement.
So you just you're working, you've had this job for a while. Now your employer comes to you and says, "I want you to sign a new employment agreement." Well, guess what? That's always bad news. Your employer is not going to come to you out of the blue, ask you to sign a new employment agreement that provides you with better terms, better protections than what you would otherwise have. No. So it's never a good thing. But the key here is this: you can't be penalized, right? You can't be fired for cause. You can't be disciplined for refusing to sign a brand new employment agreement. You can say, no, I'm happy with what we have, and I'm not going to sign a new one. And in many cases, that's much better than signing an employment agreement that takes away rights, like I explained earlier. So be mindful of that. At a minimum, if you're an existing employee, your employer comes to you and wants you to sign a new employment agreement, let me see it. Send that over to me. Let me read it and tell you what it means so that you know and make an informed decision.
You did mention earlier, though, if you do sign it as you're already an employee, do they have to give you something to make it enforceable?
So if we're going to get kind of more technical about this, if you're an existing employee and your employer says, I need you to sign a new employment agreement, for that employment agreement to be enforceable so that your employer can rely on it, they have to give you something in return for signing. It could be a one-time signing bonus. It could be a pay raise. It could be extra vacation, something that you wouldn't otherwise have. Because if nothing changes, everything's exactly the same. You don't get anything, but you still sign that piece of paper, it's likely not going to be enforceable. Your employer is not going to be able to rely on it. But again, bad advice to think that you can just sign an agreement thinking it won't be enforceable. My rule is that if you're not happy with what the agreement says, you shouldn't sign it.
And that dovetails nicely into number 4, Lior, which is parts of an employment contract may be unenforceable or legally outdated, too.
Correct. So laws change and requirements of an employment agreement change. So for an employment agreement to be kind of state of the art, that employer or lawyer for the employer have to update that regularly to know what the law says and make sure that it kind of is in line with what our courts are requiring. So just because you sign an employment agreement, maybe a couple years ago you didn't see the show, you didn't know who I was, and you signed an employment agreement, and now your employer says, well, it limits your severance, so we're going to rely on that. It may actually not have the effect of doing that. It may now be outdated, or there may be ways around it. So this is just a long way of saying is, if you made that mistake maybe of signing an unfavorable employment agreement, there may still be hope. We may still be able to get you out of it. Call me, especially if you lose your job. Your employer may say to you, well, under Section 6 of your employment agreement, we only have to pay you this much. And you may think, well, that makes sense. It may not. You may be able to get out of it. Call me always if you lose your job, even if you sign an employment agreement.
One more point to go on this, Lior, talking about employment agreements. Employees can seek out legal advice from an employment lawyer before signing that contract. In fact, they should, right?
A lot of what I do, John, is I spend time reviewing employment agreements, helping individuals negotiate those employment agreements, and I want you to do that as well. It's such an important document. If you think about it, we spend more time at work than we do anything else. And the employment agreement is the document that governs that aspect of our life. It's an important document. Don't just sign it without me seeing it.
Short break, guys. We'll get back to more. We have a website called terminationquestions.com. That's where we're going to go for our next question on the other side. In the meantime, call Lior anytime, 1-855-821-5900 and help@employmentlawyer.ca. We'll continue. More of the Employment Law Show's coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. As I mentioned, terminationquestions.com, yet another website for you to use, easy and anonymous. You can ask your questions and they will get answered, maybe on this show. But other than that, Lior's got a team that takes care of those as well. For today, Lior, it goes like this. I've been working for the same manufacturer for over 25 years. The owner has decided to sell the business, and we've been told by the new owners that only half of the workers will remain on. I'm almost 50 years old. Am I owed anything here?
And that happens, of course. That happens in a situation where there's a sale of a business. Sure. You may or may not end up continuing to work. You may or may not have an opportunity, a job waiting for you with the buyer. But guess what? The good news is you still have your severance rights, and those could be very significant. So let's, of course, use our severance calculator tool to see how much this person is owed, because he has significant entitlements. And the reason why you always want to check your own rights is so that you're not surprised, so you're not being out there not realizing what your rights are, because it can get confusing. We're going to go to pocketemploymentlawyer.ca, use our severance calculator tool, and let's see what happens with this gentleman. They may not have a job as a result of a sale of a business. So he's in manufacturing, been there for 25 years, almost 50 years old. We don't know exactly severance, no severance. Well, we know what he's owed. 18 to 22 months is what the law would provide for him. So he has that assurance now, that confidence that if he does lose his job, he's going to get paid for a while so that he can find another job. That's what severance is for. It's there to help you while you transition to new work.
You want to join Lior and his team on the live stream on YouTube and Facebook at ST Lawyers, to join that conversation. Here's the question from it for this week, Lior. After a recent performance review and some mistakes I've made over the past few months, my manager has informed me my probation period will be extended another 3 months. Is this legal?
Well, it's legal in the sense that there's no law that says you can't do that, but it's meaningless.
Yep.
It doesn't do anything. And the reason for that is you can only be let go with no compensation in the first 3 months of employment, and only if you sign an employment agreement that says that. First of all, probation is not automatic. You're not on probation just because you started a new job. You're only on probation if you sign an employment agreement that says first 3 months you're on probation, and during that time, if we let you go, we don't have to pay you anything. If it says that, then you are on probation. But let's say your employer says, we're extending it. Well, what does that mean? It means nothing. Because if you're let go after 3 months, you're still owed severance. So whether the company says you're on probation or you're not on probation, it's not going to change what you are owed. So if a company puts that in, I wouldn't lose any sleep over that. If they're extending your probation, if they're saying that, it's not going to matter. What is important to remember is if your company extended it beyond 3 months, and then before the end of that extended probation period, they say, oh, you didn't meet it, so we're going to let you go. I want you to remember, you are owed severance. Remember what I said earlier. Even as a short service employee, your severance in most cases is going to be calculated as months, not days, not weeks, months. So that's why even if you're supposedly on probation, you may still be owed several months of severance if the company lets you go. Call me if that happens.
We are to that part of the show where we get into the employment law show, Rapid Fire. All right, pal, number one, tuck in. Here we go. Your employer can request detailed information about your medical condition.
No. Your employer cannot demand, require, or threaten you into disclosing information about your medical condition. Your employer, that's offside. Your employer can ask for situations where they need to know about what accommodation you need, what is the prognosis, when you can come back to work. But your medical condition is personal, it's private, and none of the company's business.
Prognosis, not diagnosis, correct?
You got it. That's the way.
Number two is this. Your employer is legally obligated to investigate and resolve harassment complaints.
Legally, by law, an employer has to take harassment complaints seriously, to investigate and to eradicate that harassment. It's not a nice to have, it's not the ethical thing, it's the legally required thing. So if your employer doesn't take harassment seriously, they don't investigate, they're not doing what they can to fix that problem, they're in violation of several statutes. You always call me if that happens.
Number three, rapid fire. Your employer should provide training and support if you're struggling to perform adequately.
Absolutely. If the company wants to performance manage someone, they have to do their part of that. So it's not good enough to say your performance is not very good, therefore we're going to penalize you. The employer has to offer help, support, training to improve that performance. If they've done that, they've met their part, and the employee still cannot do the job, then maybe discipline is appropriate, and maybe then they can consider termination for cause they can't avoid doing their part of it.
Rapid fire number four. Your years of service should continue if your workplace is sold and you're retained by the new owner.
Yes, absolutely. If your business is sold, you continue working with the buyer. They inherit your service unless you sign an employment agreement that says otherwise. Again, that employment agreement, very important.
And finally, in a rapid fire for this week, Lior, your employer must provide a valid and legitimate reason for your termination.
That is false. Your employer can let you go without a valid reason so long as they pay full severance.
And we're done. Rapid fire. Love that segment. We'll do it again next week. In the meantime, reach out to Lior anytime and his crew. Always ready to answer your questions. 1-855-821-5900. help@employmentlawyer.ca. That email address we use. And that website you'll want to use anytime. pocketemploymentlawyer.ca. And access to the severance calculator. We'll catch you next time on the Employment Law Show. Thanks for tuning in.